I'm Tina Burgos, Chair of the Needham Human Rights Committee. This is a meeting of our subcommittee to discuss the discrimination complaint process that we are trying to put into place for the town of Needham. If you guys could just introduce yourselves, that would be great. Amelia?
I'm Amelia Klein, and I'm on the committee and have been for many years. And I'm very interested in finally reaching a point where we have this initiative in place.
Great. Julie?
Julie Venables. I've been on the Human Rights Committee for several years and am part of this subcommittee that has been meeting for several months.
Chris?
Hello, everybody. I am Chris Heap. I'm the town attorney.
Should we give it a minute to wait for Marlene?
Tina, Marianne's an attendee, so I'll move her over now.
Okay, here you are.
Hi. So sorry.
It's okay. We just did introductions, Marlene, if you wanted to do a brief introduction.
I'm Marlene Schultz. I've been on the Human Rights Committee for years and years. I was on the initial one in the 90s that started based on fair housing. And I have been involved with complaint process and adjudication, both when I was on the Arlington Human Rights Committee and on commission and the Cambridge and Arlington Human Rights Commissions.
Okay. Hi, Marianne.
I'm Marianne Cooley, Select Board member, and I have tried to attend these meetings when I can. I think I've made it to 3 of them. So just we're looking forward to this process becoming a reality. So I appreciate all the work that you are putting into bringing it to fruition.
Okay, so at our last meeting back in June, we presented our very rough draft of what Marlene and Julie and I had come up with. And this is after discussions with Chris, with select board members, with Chief Schlittler, and researching what other towns are doing. We did not get past the first slide, Chris, because of privacy issues and because of open meeting law. Am I remembering that correctly, you guys?
Yes.
So we're basically stuck right now at how do we, once a complaint is submitted, you know, what are we allowed to do? What are we not allowed to do? What are the ramifications for privacy and open meeting law once we get the complaint, because we are a body of the town government? You know, a lot of questions like, obviously the privacy issue came up. How many people are allowed to talk about the complaint? Are we allowed to present the complaint to the committee? And if we do that, what next? So there were a lot of questions and concerns regarding all of the different stakeholders involved, and you know, what's the best course of action to make this happen?
Sure. And I don't know that I have a great solution to offer because I think the reality is that the HRC is a town body and therefore, you know, subject to both public records law and open meeting law. There are, I think, a couple of limited exceptions to both that could be brought to bear to the discrimination complaint process, at least temporarily, but you know, I don't know that there's a way to keep information protected forever. I think the challenges are that in terms of meeting, you know, the HRC and any subcommittee of the HRC needs to meet in open session unless it is doing so to consider a complaint against a specifically named individual. It can meet in executive session to discuss complaints against individuals, and individuals means individuals, not businesses or organizations. But in order to invoke that ability to go into executive session, you need to invite the person who is being complained against, which I think probably undercuts the value of that in the first place. The only, and like I said, that requirement that you meet in open session applies to both the full HRC and any subcommittees that are created to tackle the complaint process. The only exception that I can think of that would obviate the need to go in to meet in open session really is to have the complaint process be handled by one person and one person only, either one member or by staff. I know that's not ideal and probably not the way that the you guys want to handle the complaint process, but I think that's the only workaround that I can think of to meeting in open session. So that's the open meeting law part of it. In terms of public records and the ability to keep some information safe from disclosure if anybody were to ask for it, the only real applicable exemption to the public records law that would apply here is there is an ability to protect information that would constitute an unwarranted invasion of personal privacy. So that might apply to some information that we receive to a complainant. It might apply to all the information we receive from a complainant. We'd have to sort of, I think, see what the complaint contained. I don't know that I could say a complaint would be categorically exempt from disclosure, but certainly some parts of it might be. So I know that's not necessarily a helpful answer either, because that sort of requires us to examine each document individually. So those are my main concerns. And like I said, I don't know that there's a perfect workaround other than either meeting in open session and just saying that's how we're going to conduct our business, or having the complaint process be handled by an individual, either a member or staff. I guess, but I did hear Marlene's comment that she has worked in both Arlington and Cambridge. If they've handled it differently, I'd certainly be interested in knowing
Right.
how they did it.
So in those places, first of all, they were commissions, which I think means they may have had a little more autonomy than a committee, a town committee. I mean, they're still part of the town and responsible to the select board and appointed by the select board. So those were always discussed, which is the reason I thought we would bring it to the meetings, which are open meetings. But we didn't use the people's names. So, I know that when we had discussed complaints before we had this process, when we in the past have discussed complaints at our meetings, and we have a liaison from the police, sometimes they would say the person was known to them, and sometimes they might say that the person was not known to them, which was really helpful. So that's when you need to know to use the name. And I think that if in our paperwork, if we're very clear that this would be discussed in a public meeting, then we could use the name. If they gave us permission, if they submitted the complaint and then gave us permission to use that. And
Marlene, you're just talking about, because there were two sticking points when we last met. You're just talking about once the complaint is received,
right?
Your thought is to then present it to the rest of the committee to see if it truly does constitute as a human rights issue, and then we would move forward with the rest of the process.
Right. So yeah, I was doing that step first. Yeah.
Right. Okay.
So that's what I was saying I wanted Chris's clarification on that, which is the reason that, I felt it was important to bring it, because we want to determine, it's very possible that someone may bring a complaint that is really not a human rights issue, and it's not within our purview, and then we would need to refer the person. But if we have the whole committee making that decision, not just one or two people, I think there's a lot more weight.
And that approach sounds perfectly fine to me, as long as the committee is comfortable, having that discussion in open session. That is, to me, the easiest and best way to handle it legally in terms of complying with the open meeting law.
So then the next piece that comes up is assigning people to do the investigation of the complaint. And you're saying that if it's more than one person, that it has to be an open meeting.
More than one person from our committee, right?
Right. Yeah, more than one person from our committee. And so, so that I don't quite understand. If you're just going and collecting data, and it's very helpful to have, especially if people aren't trained or haven't done this before, to have someone who has had some experience work with someone who hasn't. But also, 2 ears are always, or 4 ears are better than just 2. And it's helpful to have someone else there.
And yeah, just to be clear, I don't have any interest in, I want whoever's conducting the investigation to have all the resources and support they need to do it. The problem is that any multiple member version of the HRC that is going off to do anything within the HRC's jurisdiction would constitute a subcommittee of the HRC. So that would be true if 2 or more of you were going off to conduct, if an investigation of a discrimination complaint is within the HRC's jurisdiction, and the HRC is tasking a handful of you to go off and conduct that investigation, you've effectively created a subcommittee that would be subject to all of the same requirements under the open meeting law that the full committee would be. That the only time that would not be true is if it were just one individual person. Or the other limited exception that might come into play is if there were staff to the HRC that was authorized to go off and conduct the investigation by themselves, and they wanted to independently, all on their own, wanted to enlist some assistance from 1 or more members. That would arguably be okay, although I'd want to think about that a little bit more. But certainly, if there's more than one of you conducting an investigation, that's a subcommittee under the open meeting law.
Cynthia, did you have something?
Yeah, sorry for not putting my video on. We're in the middle of a family scene here that's better not shared. I hear you, Chris, and I appreciate your being here. What I'm puzzled about is how the Arlington Human Rights Commission has interpreted the open meeting law as being that if they had less than, was it something like 5, Marlene might remember, 5 or 6, something less than would constitute a quorum, that did not need to be a open meeting laws, and that they usually had 2 people for the reasons that Marlene had mentioned. Again, so one thing is interpretation of the open meeting law, and it seems that other towns may have had a different understanding of that. The second part is in terms of the quality of the, as Marlene said, the quality of the investigation, to have 2 people involved, and that especially where we want to encourage people to bring cases of discrimination to this group. If there are too many requirements in terms of it going public and all, I think that will limit right away. We aren't going to get very many people, because it's not a situation that's going to be conducive. And what we learned from Arlington Human Rights Commission is the first quality that required is one of empathy and connection, respecting the person who's bringing the complaint. And I think you can do that better with two, but if right away you're going into, we have to bring this to the whole committee and this is going to be recorded in public, well, I think that's really makes it very difficult. Thank you.
And I agree with that now, and I want to be sensitive to that concern. But where this body is a an entity of the town, I think we do need to be realistic about the level of and candid with anybody who files a complaint about the level of privacy we can offer them, because I think it is limited largely by the pressures on the town that are applied by the public records law and the open meeting law. I mean, it is the public records law is not, and the open meeting law are not, they're not geared towards, the town being able to offer individuals privacy when they submit documents or information to the town.
So I wonder how Arlington and some other towns who are in the same state are able to do that. Because if we aren't able to do that, maybe we aren't the group to be doing this. I'm just raising it.
No, I'm interested in learning more about how Arlington manages that juggling act between, investigating complaints and encouraging people to come forward with complaints, and being sensitive to disclosing information that the town receives.
Right.
I just want to chime in and say, I did talk with a town manager in a neighboring community that has one of these complaint processes in place. And I will be honest that, the unofficial response was that they had not been asked for a public record. So I'm not sure that we can conclude that they wouldn't have to provide the records. They just hadn't had a request on a case. So I think, from my perspective, it's better for us to be aware of all the pitfalls on the front end while we're creating this process. So I'm not sure that it's a different interpretation of the public records law. It just hasn't necessarily been tested.
I don't think
Mary
that's
Ann?
what we're talking about, the public records law. We're talking about the investigation right now, so that's different.
I just wanted to ask, I guess, Chris, there's not any fundamental issue related to being the Human Rights Committee, which is advisory to the Select Board, versus being a commission that has any play in this particular matter. Does that make a difference?
It does not. It does not. Any local body, however created and whatever authority they possess or don't, is subject to the open meeting law, even one that is advisory to the Select Board.
And I had thought I understood, and maybe I didn't, because Cynthia just said something else. I thought I understood that Arlington's investigation process just involved a single person, which was how they were getting around it. But I think Cynthia indicated something else. So maybe I misunderstood their investigatory process.
Yeah, they had said that they have 2 or 3 people, I think, on each case.
Okay.
I have a question, Chris. I don't know if I understood you correctly when you said there's certain, some very rare cases where you can exempt some information. Is there a way where we could exempt people's names like across the board, or is that not, would that not fall under that?
So the exemption there is that we're allowed to withhold information under the public records law that would constitute an unwarranted invasion of personal privacy if released. I would be comfortable saying that we could withhold someone's name from disclosure. If if they had made a complaint for investigation. I think that would be okay.
Okay, so we could have open meetings and never mention someone's name. That would help alleviate at least some of the privacy concern with the open meeting portion of it, right?
Yes, which I think is consistent with what Marlene said Arlington had done, at least as the preliminary stage before the investigation got going. That sounds right to me.
Okay, thank you.
Marlene?
I mean, I've also been in the situation where a complainant has come to the meeting. So obviously that's an open meeting. And so then it's not the privacy issues. The person knows that they're in an open meeting, so that's clear if they want to present their case. And that's another thing that I had done in the past, is that if the commission had decided that this was within our purview, we might invite the complainant to come and to speak their piece, to give us more description, which is always very helpful. What I'm concerned about is the investigation piece. Yes, we could go and say just one person, but that just makes me nervous. And I don't know, and I guess maybe what we need to do is find out how the other towns are getting around it, or how they are interpreting the law.
But we could also do an open meeting if it's like, say it's me and you, Marlene, on the investigation, and we know that we can exempt this person's name, then we could theoretically have an open meeting where you and I are discussing this, our investigation.
Well, but an investigation means either calling the complainant,
I don't know how do you
going to meet with the complainant, maybe at their home,
Okay.
and that's not conducive to an open meeting.
Right, so Chris, how would that work? Let's say we're in the investigation process. One person is assigned to talk to the complainant. The other person is assigned to reach out to, the various other witnesses, organizations, to gather as much information as possible. What does that process look like?
I don't have a good answer to that. I honestly don't know that it would work in the context of an open meeting. If you need to go out into the field, speak to multiple people, or I don't know that would work logistically. To me, that suggests that the better practical approach might be to delegate to one member or to an employee of the HRC to conduct the investigation and then report back. I don't know. I don't have a good answer to how that would work comfortably under the open meeting law.
But at some point we would, if there were more than one person involved, the findings would have to be reported back to the committee in an open session. Is that basically what you're saying?
Yes, unless it were possible for that one member to suggest a solution to the complainant and the person who's been complained against unilaterally on their own. I'm not suggesting that you delegate that authority to whoever's conducting the investigation, but it might be possible in some cases.
Katie?
Just to clarify, I guess, if it were two members of the HRC doing the investigation together, if they're just fact finding and then make a recommendation for the next step after they do that fact finding to the full board in an open session, is the fact finding that they're doing considered a deliberation? Or is it just that they're, right? I'm trying to figure out, is it that because those two people are making a decision on behalf of the whole body, or if they do the legwork and bring the final decision back to open meeting, could they do that in private?
I have not, I don't, if the investigation is part of if conducting an investigation of discrimination complaints is something that the HRC does, it's within the HRC's jurisdiction, and we're tasking 2 members to go off and conduct that investigation. I believe doing the investigation itself would be a deliberation under the open meeting law. I can think about that a little bit more and maybe try to weigh how Arlington's treating this, but no, I do believe that conducting the investigation, if that's within the HRC's jurisdiction, is a deliberation for purposes of the open meeting law.
Marlene?
I don't see it as a deliberation, it's fact finding. So if you collect the facts and then you bring them to the committee for their next meeting and say that, you know, this is what we've learned. And then in open meeting, the committee says, makes these suggestions, let's move forward this way or this way. So why would you say that the fact finding, when there's really not a deliberation, it's just getting all the information?
I think deliberation may be a little bit of a misnomer under the open meeting law. It doesn't exactly mean deliberation in the sense that we would use it conversationally. It means under the open meeting law, basically discussions between multiple members of anything within the board's jurisdiction.
Can I ask another question? And this has to do with when the Human Rights Committee is actually meeting together. I remember at least one time where we had what was called an executive session, and I don't know when that's allowed, but I think one time, one of the cases that was brought to us, it was a letter from a person who had complaints about how she had been treated, and it was a very complicated situation with, I'm sure the letter could probably have been said that was a document to be shared, but there were many very personal parts to it, and the police liaison had some things to offer, and we were really trying to figure out how we could fairly respond. But I think that was one time when we went to an executive session, because it would not have been good to publicly record what was going on. And the police liaison was able to share some things about police involvement with this person in a very compassionate way, what they were trying to do to help us to decide that there really wasn't anything more we can do other than write a letter showing concern for the individual. But that was, I tried to think, and I know Marlene and Amelia have brought up situations we were involved with before. I try to think of those as a guideline for what would this look like. So that's the only other thing that occurred to me, is the idea of an executive session.
Sure. And I gave that some thought as well. And there may be times when the committee can meet in executive session, but the one case in which it can do that is to discuss a complaint against an individual. So the complaint process would certainly qualify for that part. The only catch is that in order to go into executive session to discuss a complaint against an individual, you must give the person who is the subject of that complaint at least 48 hours advance notice and an opportunity to attend in the executive session. So that would, that may be useful in some cases and at some parts of the process, but I don't think that's going to be helpful generally, because at least initially, you're certainly not going to want the party who's been complained against there for the meetings.
Well, so now that we have this information, what are you guys? I know we need some time to kind of absorb it all, but how does it change what we talked about in June? I know there was very strong pushback against one person handling the case, and I completely understand why. So I don't think that is a path that we want to take going forward. That was just the consensus that kind of came out of that discussion. Marianne.
Chris, do you need to understand what's happening in Arlington and why it is different? I mean, and Katie didn't name Arlington, so I'm thinking that's not the community that she spoke to. But do we need to learn if their process is not compliant and they just haven't been asked about it, or if there's something else that in fact we're missing that is protecting their process?
I would like to learn more about exactly how Arlington handles it. I can anticipate. I think anticipate some of the arguments that they may be using. I don't know that I agree with them, but I'm always happy to reconsider. The advice I'm giving you guys if it's going to make the process work better. So no, I do think that if Arlington is out there doing this the way we would like to do it, I guess I do want a better understanding of exactly what they're thinking.
Marlene.
So, Chris, does that mean that you would get in touch with them, or you want us to get in touch with them? How should we move forward? We had the vice chair come to one of our meetings and discuss it. Marianne was there, and I think Mo was there maybe that night. And they presented it to us, and I've been in touch with him a couple of times. They actually get a lot of their referrals from the select board and from the police. Mm-hmm. So I can't imagine that they are out of compliance in any way. But since you sort of speak the lingo better than we do, I'm wondering if you would be willing to do some outreach and see what we're missing, or how we might be able to tweak this in a better way.
Happy to do. I'm certainly happy to do that. If you had a contact who came and spoke, maybe it would, I think, be helpful if you wouldn't mind sending me whoever it is that was.
Yeah, I was the contact for him, and I'm happy to do that. I don't know your email. Maybe Katie can send it to me.
Yeah, I can connect everyone, and Chris, we can connect with the town manager in Arlington and make sure that you have town council. I agree. Having lawyer talk to lawyer would probably be most helpful.
Yeah, Katie, we can also send him the minutes from. I mean, you can listen to the recording, but the minutes are a little bit faster to read. That's the summary of what they presented, which is what we're kind of, I mean, Marlene knows far more, but that would also show you what we have, our understanding. Of course, we could have missed some of it.
It's also, the process is on their website as I think as a good kind of starting place.
I will immediately go take a look at that. And just out of curiosity, how long has Arlington's process been in place? Do you know?
A long time. I think it's changed. It's changed a bit. Well, it's much more formalized since I was on it. I've been on this one for 10 years. So it was 10 years ago that I was there.
Okay. My only thought is that the question of subcommittees under the open meeting law has become sort of a hot new issue in only the recent past. So I'm wondering if this may have been something that they properly didn't think about too much when the process was instated a long time ago, that may be the subject of some new guidance now. But I don't say that to discount the importance of looking at what they're doing, which we'll go off and do right now.
Just with regards to open meeting law, is that what you're talking about, Chris? Okay.
Yeah.
I think that would be really helpful, because I know when we heard the Arlington process, I think it has a lot to recommend it, and it sounded like something that we would like to replicate in Needham. If there's a reason that we can't do that, then we just need to be sure that we know what it is. But if there's something that we've missed in our process putting it together that is the key to their success, we also need to understand that.
I agree.
Does anybody else have any other questions? And Amelia and Cynthia, I appreciate you guys joining today, because we, as you know, our last meeting was pretty, there was a lot of discussion around it. So it's helpful to get more ears on this so we can try to figure this out. Anything else? Oh yeah, Marianne.
I would just ask then, what is a reasonable time to get the group back together? I mean, what does Chris think? Because I do think that understanding that from a legal perspective is critical right now. And I also worry, I just want to say back to, Marlene raised it, I think Julie raised it, I do worry that having it completely an open session is a barrier for some folks. So, what we do want to understand what our options are.
I don't think I need long. I can be ready to go back over this. That's effectively, I think, as soon as you guys are ready to meet again. 2 weeks, or I would say maybe 2 weeks out, but sooner or longer, depending upon your schedule, is fine with me.
I have a follow-up question to that. So let's say somebody does not want to they really do not want to involve themselves in an open session with the committee. Where would they then go? Because that would be terrible for us to say, we can't help you, and then just send them on their way. Like really terrible.
So in order to, I don't think I didn't mean to suggest that a complainant must appear in an open session. I think there are certainly ways to avoid that. The complaint could be taken in administratively, reviewed by somebody, and that's the open question here. But I don't know that I envision a scenario where the complainant needs to appear in an open session. The HRC can discuss the complaint without the complainant present, I think. And I think we can go so far as to discuss the complaint without using the complainant's name, because that would be something we could protect under the Public Records Law.
Okay.
Yeah, I think that part feels like fine to me. It's just the investigation that's now this sort of stumbling point, it sounds like.
Right.
Yep.
Amelia?
This is probably a very naive question, but I wonder if there's a way to challenge or to petition someone at the state level in charge of the open meeting law. I'm thinking of how difficult it would be for someone to come to a committee, to have the courage to come to a committee about something involving racial issues. And we did have a very sensitive case many years ago of someone who came, which also involved a police department official and interaction with a person of color. And I mean, I just think I agree with Tina. We just have to find a way of being a place for people to come in the community with issues like this, particularly the more sensitive issues. And it's one thing to talk about a noisy neighbor in the housing authority, or a concern about a teacher or a school official. But when it involves racial issues and very personal experiences that people are having in our community, I think we really have to think carefully about how to connect to those, or how they could connect to us so that we could support them.
I completely agree. And I think you correctly noted that, well, a legislative change to more readily allow for this would be fantastic. That would be, I think, a welcome change. The current state of the open meeting law, though, is that because, I mean, ideally, the whole committee should be able to meet with a complainant to discuss these things in closed session. I mean, that's the ideal way to operate and the ideal way to handle the complaints. But under the current version of the open meeting law, the current version of the open meeting law does not contemplate this kind of meeting happening in executive session. So there's a list of reasons that a local town board can go into executive session, and it's got about 15, 16 different, reasons on it. Adding this to the list would be, I think, a welcome change.
Marianne?
And while Chris is saying it would be a welcome change, it's not easy. The answer is making any changes to the open meeting law is hard and painful, but that doesn't mean that we shouldn't try and have this discussion with our representative. But they're rare is all I can say.
Marlene?
I'm curious, Chris, when the latest open meeting laws were revised, updated, whatever. How new or old is this?
It was revised fairly recently, but there was no change, I don't believe, to the list of reasons that a board can go into executive session.
That's my understanding also.
The changes were more to posting requirements for agendas on the town's website and things of that nature.
Okay. So Chris, you said a couple weeks?
I don't know when your next meeting is, but I could certainly be ready for that, or before, sooner or later, depending upon your preference. Just let me know.
We're meeting on the 19th. Do you guys want to try to tackle both issues at once?
Just ask
Yes.
if we could do a separate meeting, if it's possible.
You want a separate meeting?
Yeah, if it's possible, yeah.
I actually can't attend the 19th meeting, so I would prefer a separate one too, selfishly.
Okay. So why don't I email you guys with some dates after the 19th? After the 19th, is that better for everybody?
Well, wouldn't it be nice if we could do it before the 19th and present it?
On the 19th?
Yeah.
What's availability like for everybody over the next week and a half?
I can meet pretty freely up until the 17th, and that's when it becomes a little harder for me.
Okay, why don't I send you guys an email with a few dates and times? And we can try to figure it out.
Including Chris, because he's key.
Yes. You guys collectively.
Okay.
Katie, also just the September meeting coincides with Yom Kippur, is that correct, Marlene?
Yes.
So we need to change that. But I'll touch base with you on that.
We usually go the Thursday after, but you could go the Thursday before, depending if there's anything else.
Okay. Anybody
I
have any other?
Look at the
Go
school
ahead.
calendar. That helps to know when to have meetings.
Okay, and then the other thing is there's a call out now for Marcus has resigned. So we have 2 positions to fill and 2 student positions to fill.
Or one student. We never had 2 students before this past year. We always just had 1.
Oh, really?
Yeah.
Okay, so I have 2 interested, but I know with Sandy leaving, there's a gap in communication with those 2. But I'm going to post something on Facebook, on our Facebook page as well. So if you have any additional suggestions to what you guys have sent me, would you please send them along so we can get the ball rolling?
It should be posted too. I don't know. Has Sandy had a replacement, Katie?
No, not yet, but I can follow up with Kate and Marianne. You may know more than I do right now.
So I know that they were identified when Kate and I went through all the appointments, that these were both things that do need to be advertised. I haven't seen the advertisements go out yet, and I don't know whether Kate is waiting for Sandy's replacement to start or whether there's an intent to get it out sooner. That I'm not sure about.
There's also an issue now about where things go, since many people are no longer getting the Needham Times. So I don't know how we deal with that, but that's a whole other issue.
So I think our intent, Marlene, is we're hoping to take advantage of the list that the town has email wise to reach people, taking advantage of the various Facebook pages, so yours and the towns and the Needham community kind of page, getting it relayed there, that are links to ICON and to the AAPI community, out through the Resilience Network folks, that we would go out through all those channels with the various openings to try to get it out to as many email lists as we have access to, is what we're going to try to do. You're right, people aren't getting the Times, but I'm not sure how many people read the Times in the past either. So, to be fair.
Okay, yeah, because we're gonna need help.
Right.
Yeah. I'm anticipating
So
help.
I'm actually glad to
Need it.
hear that you have a couple of students who might be candidates. So that was
Yeah.
one of the areas that Kate and I had talked about, what we would have to do to try to some students.
We have
So,
three students so far that have expressed interest. So
good.
So
Okay.
just, Amelia.
And I believe we have some people that are interested, potential candidates for have we talked to them or have we reached out to them?
Yeah, I mean, the last communication was Sandy will follow up, but that was obviously, that's.
Yeah.
She
So
has that.
Tina-
Yeah,
Tina, I wanted to say to Amelia that we're going to be back in touch with Renaz Mala, who has attended some of our meetings, and there was no opening at that time. So I think Tina said that I can encourage her to be in touch with Tina to talk more about it, and that Amelia and I have both been encouraging her.
So if someone were to fill out an application, Marianne, what would happen? Because I think in the past, Sandy would have seen it. So where would it go now, since there's no one in that position?
I can answer that. We can see it on the back end. So even though her position isn't filled, we're getting her emails and everything submitted through the town website. So I can check with Kate just on the timing, but and Tina, we can just connect to make sure I have everything that you had given Sandy. So we won't miss anything. It's just
I saw that
been-
email.
Yeah.
Okay,
Good. Okay, Chris, I will send you the information about who we met with in Arlington, and then I don't know who legal counsel is, but I can at least tell you who the commissioner was.
Figure that part out. That's great. Thank you.
Okay, thanks.
Well,
and go ahead, sorry.
Well, I'm just thinking we could also send Chris the link to the meeting where the Arlington person presented, so he could watch it on double time and just see what was heard there, maybe perhaps before he talks to their legal counsel. So
That'd be great.
Katie, will you send that?
Yes.
Thank you.
great.
Anything else? I will email you guys. I know I owe you guys a bunch of emails. I promise you, I just have to get through this move by the weekend. So, but you'll hear from me. Okay,
Thank you.
Good
Tina.
luck.
Good luck with the
Okay.
move.
Hang
Luck.
in. Yeah.
I'll talk to you guys later.
Thank you.
Bye. Thank you, Chris.
Thank you. Nice to meet you all.